to our second subcommittee of our Non-Discrimination Ordinance. We have a special guest with us today, but before she's introduced, I'm gonna hand it over to our mayor to welcome our newest commissioner and the person who will be talking to us today.
All right, fantastic. Don't know who all of our participants are, but I believe you just said our newest commissioner has joined us. So I want to welcome newest commissioner, but certainly not new to Augusta's commission and the government, Commissioner Alvin Mason from the 4th District. We welcome you, Commissioner Mason, to this important conversation. In addition to that, we're joined today by a very special guest, a friend who's no stranger to Atlanta, to Augusta, and certainly to matters when we begin talking about non-discrimination. And that's my friend, Kathy Wooler, former member of the Atlanta City Council, former Atlanta City Council president, having served from District 6 in Atlanta, and then being elected to serve as the president of the council back in 2002 to 2004. Again, I'm excited. Kathy's been a stalwart in helping to shape good public policy around a host of issues that are inclusive, that help create equitable and inclusive communities. The city of Atlanta has been the great beneficiary of the work that she has done. And so we're pleased to have her joining us on this meeting today. We have heard from her before in previous sessions where we've had a working group meeting, along with many of our partners and stakeholders who are part of this conversation on today. And so with that, Madam Chair, my good friend and leader, Kathy Wooler.
Thank you so much. That's a wonderful introduction. I appreciate that, Mayor Davis and Commissioner Scott. Thanks for letting me be a part of this. I'm not exactly sure how you'd like to handle it, but I'd be happy to just kind of give you a really quick thumbnail of the experience Atlanta has had with this type of ordinance. And then I've been working with commissioners from other cities around the state who have an interest in this. So while I can't answer real specifics about every single jurisdiction, I can certainly tell you about trends of things that may be on your mind. And real happy to answer any specific questions if I'm not hitting on the things that concern you the most. So you feel free to put them in the chat or just interrupt me. And I'll kind of move quickly so I don't take up too much time, and then we can do whatever the Commissioner Scott says we need to do. But when I was on the city council and president of the city council, a number of my constituents came to me and said, you know, Georgia is one of 5 states that doesn't have comprehensive civil rights legislation. So legislation that covers all the federal classes in employment, housing, and public accommodations. To be frank, I was rather flabbergasted about that. I'm not a lawyer. I didn't know that, and thought that Georgia would have been, you know, one of the leaders in having these kinds of protections for people after our history in the civil rights movement. But that is not the case. And so as we began to have conversations, the biggest question we had was, did we as a city have the authority to do this? What we discovered in the research is that the Georgia Code is silent. When the code is silent, cities can act. We enacted our legislation about 20 years ago. We've not ever been preempted, nor has anybody challenged the law itself. In recent years, about 13 other cities have passed ordinances such as this, and I'll go into the experience that they've had. I'm going to look at a couple of my notes so I don't forget to tell you a few things. So all of the NDOs share certain things in common. All of them prohibit discrimination in employment, housing, and public accommodations. The protected classes in all of the Georgia NDOs are all of the federal classes, plus sexual orientation and gender identity. A few of them move beyond the federal classes into some other specifics that those jurisdictions would like to cover, but they all have that minimum number of classes. They all have exemptions for the non-commercial activities of religious organizations and nonprofit private clubs. They have exemptions, for discounts for children, families, and seniors, and bona fide affirmative action plans of things you'd like to see. And these non-discrimination ordinances have no authority over the decisions of local school boards. All of them have local enforcement and resolution options. I'll talk about that in just a minute. All of the ones after Atlanta have mediation processes, and then some go to municipal courts and some go to a hearing officer, depending on kind of the style and pattern of the local jurisdiction. So in Atlanta, let me just tell you a few differences about Atlanta. So again, 20 years ago, Atlanta passed its ordinance. We were breaking new ground, both here in this state, but really around the country. There were some jurisdictions that had these, in other cities, but for the most part, this was kind of new territory. So we really struggled with, how do you enforce something like this? At the time, and even still, Atlanta has a Human Relations Commission that is staffed by one of the city attorneys. And we determined at the time that that was the best way to go about doing the enforcement. Now, quite frankly, fast forward 18 to 20 years as other jurisdictions have started looking at these more seriously. Folks have gone to a mediation process as an opportunity to give people the chance to resolve conflict, quickly, quietly, effectively, and where that's not possible, then to go through a process of enforcing what is essentially a city citation for a violation of a city policy, which is basically the equivalent of, if you get issued a business license in a jurisdiction and you don't have the appropriate grease trap, if you have a restaurant or you exceed, capacity limits or something like that, then you could be issued a citation for the violation of that. And that is in essence kind of where this fits. So finding a way within the processes that your city has for enforcing ordinance violations is really what I think you want to look at. I think if Atlanta were to do it differently today, we might follow that option more closely now that we've seen other jurisdictions do that. People talk a lot about, that this opens a can of worms, that there'll be a deluge of, frivolous cases brought, that, it will be divisive in the community. And after 20 years of experience in Atlanta, a city with 500,000 people, and very, very diverse community, we just have not seen that. And there's probably a couple reasons. One, not everybody knows the ordinance is in existence, but also I think, people are just don't bring these kinds of things forward necessarily. So, in Atlanta, I'd say we probably don't see a 6 complaints a year. In the cities that have brought forward these ordinances, the other dozen or so, I am not aware that any of them have seen a complaint, but that doesn't mean that they haven't. I try to keep track fairly regularly. I don't always get responses back, not for any malfeasance or anything. I just, people are busy and they don't have time to answer my questions when I'm sort of repeatedly asking them. But I don't think you will see those things. Where we found this incredibly useful in Atlanta is in marketing the city for business attraction, for conventions, for sporting events. I can tell you, for example, the NCAA now actually ask the question about whether there are non-discrimination protections in their bid package, kind of questionnaires. Because what they don't want to do is get into a situation where they bring people to a community and then something happens and there's no way to unwind it. And that's where I think these ordinances are really, really effective and helpful to a community. If you have a community disruption, that's not a great way of describing it, but let's just say something happens and somebody really is a bad actor and has a business license from your community and just isn't willing to get it right. This gives you as the city commission and as city administrators, you know, an ability to kind of enforce against that if you need to. Heretofore, you really don't, right? You could have somebody, we had situations in Atlanta that frankly I'm not particularly proud of, but that people even in recent years would enact dress codes kind of unilaterally for some bars because they didn't want certain kind of clientele to go into those bars. Well, by having an ordinance like this, we were able to say, you know, you can't do that. I mean, and this wasn't, you know, a kind of a no shirt, no shoes kind of policy. This was a dress like this or you can't come in. And so, you know, it gave us a tool for getting to the bottom of it and you know, getting that business to welcome everyone without having to just go through an you know, awful situation where you don't really have the tools you need to say, look, we'll just take your business license away if you're not going to straighten up. So I think this just gives you sort of a tool in your arsenal, and you know, both for your external communications to people about what kind of city you are, but also if you do get into a situation where you just really need a business to behave in a different way, to be welcoming to everyone. That's either as an employee, certainly in housing, and obviously public accommodations is a big thing when you're talking about sort of external relations with people. I think you've done the right thing about having lots of conversations and hearings about this. You know, you want people to understand what it is, but what you also don't want to do is delay for huge amounts of time while people, you know, kind of gin up concerns that just simply have not proven out in the experience of the jurisdictions. I don't predict that Augusta is going to see, you know, kind of different things happen than we've seen in 13 very different jurisdictions, everywhere from Smyrna to Brookhaven to Savannah to Atlanta to Athens recently. You know, these are places in different political jurisdictions, you know, with different demographic makeups, with different sort of political, you know, kind of ideologies for the cities, for lack of a better word. One of the things I like about city governments is that we're not partisan, and so we can look for solutions as opposed to you know, talking points. But nevertheless, cities, you know, do have different flavors, and it's been really remarkable to see these pass in other cities and to listen to the public testimony. I'll stop there, and I'm happy to sort of direct anything that you might want to hear. You know, I can direct the comments to anything that would be helpful to you.
Thank you. Do anyone that's in the room have a question for Ms. Woodard?
Oh, I know you do, because we have this subcommittee going on. So ask anything. You know, there's no wrong questions about these ordinances. Madam Chair,
Okay.
I'll you call on folks.
So
Okay, Jordan.
Oh, go ahead.
Okay.
Thank you, Chairwoman, and thank you, Councilwoman, for joining us today. You mentioned about call volumes and things of that nature when Atlanta first passed this ordinance. I think one of the conversations that we've been having over the past few weeks have been, you know, how do we make sure that we're not creating, like you said, just this Pandora's box of extra work, so to speak. So the question I would have for you is if you could remember what the call volume was like during the time y'all passed this ordinance. I think it was fresh on people's minds. It was something that folks really wanted. Did you all have a high call volume when you first passed the ordinance? Did you see like an over, what was your staff overwhelmed with calls? Did you have to bring anybody extra in to manage the call process? What was the process like for you all once the ink dried on the paper?
Sure. We saw very few calls in the beginning, and it stayed, you know, fairly consistent throughout. To my knowledge, neither Atlanta in 20 years nor any of the other jurisdictions have had to add any staff to accommodate the ordinances. We had one back in the early days, sort of a fairly high profile case against a private country club that obviously was resolved because it was a private country club. But interestingly, all of the other country clubs in the city of Atlanta changed their policies so that they weren't even perceived to be discriminatory. So I think it was kind of a win-win for everybody because private clubs are exempt, but it still made its point. And then we've never had any other sort of case that I'm aware of where somebody was actually just trying to make a point. And again, people worry about that, but again, 13 cities, 20 years of experience, millions of people covered. If you count all the 13 cities, no one has had to add any staff to accommodate the impact of these ordinances.
Follow-up question, Madam Chair.
Yes, go ahead.
Thank you. And your enforcement process, which department, so to speak, that you all send the enforcement piece of this ordinance through? Was it your city clerk? Was it your compliance folks? What process for enforcement did you find most effective?
Well, again, Atlanta, we had to sort of make it up, right? We didn't have any other, like right now there's 300 and something cities around the country that have these now, and 25 years of experience in having these ordinances. And so, things evolve over time. In Atlanta, because we had a Human Relations Commission, it came to the Human Relations Commission via our law department, and then it was heard in the Human Relations Commission, kind of with the law department. Like I said, if I were to do it again today, I would not do it that way. It's hard, as you know, to keep commissions appointed. People roll off, commissioners got to make appointments. They're not always making appointments with this in mind. So I just wouldn't go that route. What I would do is look at any of the other dozen cities and, have a kind of consensual mediation option, because, you can imagine a situation where somebody walks into a restaurant, there's an employee acting completely under their own bias, does something, says something, acts out, not the policy of the restaurant owner, not the restaurant owner is completely aghast. You get into mediation, the restaurant owner says, I've fired this person, I've disciplined them, we've had training about this conduct, please come back, have a meal on me, and hopefully people can accept apologies and move on. But then you want to have an opportunity, either if it works with your process, to make this like literally a citation that then goes to the municipal court for resolution, or goes through an independent hearing officer that would sort of evaluate the case and either rule on it or move it on to municipal court, as it does in some cases. So I would defer a little bit to y'all in your and just sort of how you handle things in your jurisdiction, because everyone's a little bit different. But if I were writing it again for Atlanta, that's the tack that I would take.
Thank you.
Mostly just because it's just a little cleaner.
Thank you, Madam Chair.
You're welcome. I think Commissioner Mason had his hand up. I don't see him on my screen.
Can you hear me?
Yes.
Yes, thank you, Madam Chair. I did have my hand up, but a lot of what I was going to ask, a lot of it was already addressed in terms of the enforcement and so forth. But this may seem to be kind of obvious question, but for me, what is the driving force for this ordinance, and what is the bottom line that we're looking for as a result of this ordinance?
Great questions. Again, so when we did it in Atlanta, it was brought to me by constituents as ordinance ideas often were. And it was a number of public interest attorneys who said, we don't have something other than filing a federal lawsuit as an option to resolve discrimination complaints. So right now in Augusta, if there's a civil rights complaint that someone has, The only way that they have to resolve that complaint is to file a federal lawsuit. Well, that's expensive. It is high profile. It's complicated, and doesn't give anybody in the situation any satisfaction, right? You know, if you're the person that got complained against, whether you're guilty of something or not, you got a whole mess on your hands. If you're the person who feels like you've experienced discrimination, you've got a very high bar for getting a resolution, right? Going through that process is difficult because we don't have a state process for that per se. So that's why we did it. And I think that's why more and more cities are adopting these, because they're looking for a way to resolve community conflict quickly and efficiently for everyone involved, right? Because sometimes things are just misunderstandings, and sometimes things are very clearly discrimination. But as a city, having that tool can help you out of a situation that could, frankly, defame your city pretty significantly if you didn't have that tool.
Thank you. Commissioner Hassan.
Thank you very much, Madam Chairman. Thank you once again, ma'am, for being here, Commissioner Woodard. In terms of where did you all write the ordinance at the time to pretty much, I'm gonna use the word police, so please allow me, the police, all the manufacturing, all the industry, all the business across the board?
Yep.
Well, what's the benefit of doing that when many times they had that in-house? And I'm gonna kind of add on to that, because many times, if you know, the city end up finding that company in error, that person is awarded, just say $500. It within a matter of months, that company target them. Are we appropriate agency for them to get recourse? I know you're not going to through us, but have we potentially set them up that they've lost gainful employment and the city puts itself in harm's way, as opposed to doing the natural thing here when they say that 14 and under employees, the 14 and under business that have just that amount of employees, that we just cover those as opposed to trying to cover a whole city.
Well, let me see if I understand your question. There's a couple of things that I would like to point out. One, large corporations already are very compliant with this kind of law because they are covered under federal law for federal lawsuits. So just to use Atlanta for an example, you take the Coca-Colas of the world, they didn't have any objections to this because they're already doing it. Right? They're already very clear about what they're doing. Doesn't mean that they don't, have problems, within a company that big that they need to deal with, and that might result in a complaint. I'm not aware of any complaints against them from the city. It's important to know that if you enact a fine of $500, I think all the fines have to be under 1,000 because they're ordinance violations. But please let your city attorney advise you on that. That money goes to the city. It does not go to the individual making the complaint. So I just want to be really clear. No one making a complaint in this gets damages. Hopefully what they can get is a resolution to the problem, but they don't get damages through this. Why you would want to do a small business is the vast majority of the businesses in your city are small businesses. And let me just take you right back to the situation I told you about, which is the bars, right? We had a very distinct problem. Actually, we've had it off and on. Well, we haven't had it since the ordinance got introduced, but we have had it over years targeting different demographics. For the most part, those are small independent businesses operating with a city license and a city issued alcohol license. And no provision for removing those licenses if they insist on discriminating against people. And so that's why I think it's important to cover all sizes of businesses.
But what about if a person feels very, very strongly that they should be awarded some damages and we boxed them into less than $1,000?
That's state law, sir.
Okay.
That's just the problem. That is the limitation to an ordinance versus a state law.
Okay. Well, also,
Commissioner Hassan.
Yes, ma'am.
Let me go to someone else, and we'll come back to you, please.
Okay, go ahead, Madam Chair.
We're talking about business, and we do see our partner, the chairman for the Chamber of Commerce in Augusta, Sue Parr, and I believe I omitted seeing your hand up. So would you please go ahead, ma'am, if you had a comment or question?
Yes, thank you, Commissioner Scott, and nice to see you, Kathy. I think we met on a Zoom call with Chris Clark with the Georgia Chamber. So thank you for being with us today. I think my question was really to Commissioner Hassan's point, because we did have a fairly rich conversation at our first meeting with regard to the size of the business. And while this is, largely in place for smaller businesses, and that represents 73% of our members, it really, for conformity sake, I think most of the other ordinances that are already in effect, and Kathy, if you could comment on this, do cover all businesses within the county, correct?
That's correct.
Okay. Commissioner Hassan, did that answer your question?
No, I have a statement for everybody that's know from a previous experience, if you don't mind, and I'll be through.
Okay.
Okay.
Go ahead,
And that is, we had a human relations department in the city of Augusta several years ago, and that was headed up by, at that particular time, might have been where Senator Charles Walker, former Senator Charles Walker, got his start at.
It was.
And I think, and so Frank Thomas, the first Black news person, ended up the head of that the last time it existed. And one of the concerns that he had, and it was a public comment he made at Augusta Tech, and I was in the audience, and this prior to being a commissioner. And he said that when many times big businesses or businesses in general made those kinds of complaints, employees staff can make those kinds of complaints before he can get in the workplace, then elected officials in particular would get in the way, and he can never get resolution for those persons. And so I just want to be mindful. We're in a very litigious society in terms of how people operate. And I, for one, like I said, I still stand up not for the whole city.
So let me just say one more thing, or I'll say the same thing again, but point it out in that context. In 20 years of experience in Atlanta, a city with 500,000 people, we do not see more than a handful of cases, most of which are dismissed in any given year. And of the 12 other cities, so if you add up the populations of all of them, we're talking about millions of people covered every year with these ordinances. We do not see frivolous cases per se, and if we do, they get dismissed. And no more than a few complaints in any given year for millions of people who are covered. So all of those things are things that people should be concerned about, but experience has not borne out that people would have to add staff, that there would be some deluge of cases, that there would be frivolous cases, or that it would get out of control. That just simply hasn't happened in 20 years.
Thank you. I believe we have our administrator on, and he has a question.
Yes, ma'am. I'll tell you, well, more so, I guess, a comment or maybe a consideration for the commission who will be looking at it a little later. I think Ms. Woodard, or I'm sorry, Council Member Willard made a great point about how you enforce it, and even the fact that the penalties are not actually received by the complainant. With that being the case, what we have not talked about is leveraging a citation, which I think she said would be one of the considerations that she might make when you start talking about how these things are coordinated and how they're resolved. I know that we've talked about a hearing officer and we've talked about sending it through the courts, but we haven't talked about the citation program or the citation possibility and how we might move it through government. And so I think that's one area that we might want to research and look at, is just how we actually manage these cases, and how a citation protocol, or when we look at the limits that are placed by the state on fines, how we actually coordinate that, because that'll be a big part of any concerns that you have, I think we can resolve those administratively in how we actually adjudicate these potential cases.
Those are excellent points. And so what I would say is, don't look at Atlanta's ordinance as you're investigating this, because we just don't do it that way. But look at all of the other dozens. Most of them have sort of a graduated 2 or 3, like if $500 on the first violation, $1,000 on the second violation, the ultimate is the potential to remove a business license. Let me just say, I don't know that anybody has ever done any of that, because I think things get resolved differently. But that's sort of a little bit how you as a city have the opportunity, if you have somebody who is determined to be a bad actor. I don't think you're going to run into that situation, but that's why that's in there. Because you are the issuer of the business license, which gives that business the opportunity to make money in your jurisdiction and to operate in your jurisdiction, and you regulate tons of things. This is one more thing you're regulating to say you must comply with our ordinance of non-discrimination, either in employment, or if you're in the housing business, or if you're in the public accommodations business, as a condition of doing business in our city.
Thank you for those comments. Commissioner Mace, McKnight, did you have your hand up?
No, ma'am. I'm just listening. Thank you, Doug.
Thank you. Commissioner Mason.
Thank you, Madam Chair. Can you hear me now?
Yes.
Okay, thank you, Madam Chair. Ms. Woodard, we've heard, I'm hearing a lot of the pros as it relates to this ordinance. From a historical standpoint, can you speak to any cons and or does it vary from ordinance to ordinance or city to city?
Well, again, I think the biggest negative that I would say in these ordinances is the one that's in my own ordinance, which is the use of the civil rights of the Human Relations Commission. And let me just say, it hasn't been a disaster. It hasn't been a bad thing per se. I just think keeping commissions fully populated and supporting the work of volunteer commissions is a layer of difficulty to these that isn't helpful, particularly to anybody. But as I said, when we did this 20 years ago, we had no other example of how to do it. And I think the folks that have done it in the last several years in the other dozen cities or so have been able to benefit from the 20 years of experience in over 300 cities around the country that have enacted these. And they're starting, to sort of model what other cities have done. And then here, looking at each other. So what I would do, it would encourage your city attorney to do, and for y'all to do, is look at the other 12 or pick some and that seem the most coherent, with the way you operate, and modify from there. Doraville started by doing it in this different direction, and they modeled it off of a city, I think it was called in Clarksdale, Mississippi. They modeled their ordinance off of Clarksdale's ordinance, and then, which is also why they have a hate crimes piece in there, because Clarksdale did, and they just kind of took it whole cloth. But then, other cities have done little modifications along the way, but they're all vastly similar. And Atlanta's is just really different. But again, I think we made something a little more complicated because we just didn't know how to do better.
Yeah, and that's one of the reasons I wanted to bring you on. And we're not going to rush this process. We're going to, I think we'll do better when we know better. And that's why we asked you to come on today, and we'll be asking other cities who have implemented a NDO. So we won't have to reinvent the wheel. We'll just go with what we think is right for Augusta. One question I might have not was hearing, did you have a lot of pushback or negative response from the business community? And not just the big business, but the little small businesses as well. Because sometimes if I really believe in training, and because if you know better, you'll do better. And that's something that I'm looking at to see if we can implement. But because if we do a $500 and then you go to $1,000, where if you got a mini business, $1,000, $1,500 is a lot of money to lose when you're not making a lot of money anyway. So did you have a lot of pushback from say community businesses?
It was 20 years ago, so trying to remember. It was late of a night that we did. We had some, but not a lot. And I don't know why. I think that there was probably, lots of things going on at the time. But I have been in public hearings in all of the 13 cities that have passed them. I've monitored the processes and worked with commissioners. And while I would say that businesses raise concerns, again, the vast majority of businesses are either big enough that they are cognizant of their responsibilities in this regard. And as you said, they're trained so they know better. Or I'm not even meaning to imply that smaller business owners know better, because I'm a small business owner and I do know better. But I would say that the business community has been very thoughtful and analytical. And that, and while there are concerns, particularly as regards to companies that may not be currently covered under federal law, for the most part, large companies have come forward and been supportive, because they're there, they know what they have to do. Where we see some commentary that I find frankly quite alarming, and we've seen it particularly explode in Macon, was some organized groups that wanted to focus this on transgendered individuals. And I wanted to bring that up because I want you to be prepared if you see this kind of talk. The two focused areas are transgender children and people playing sports. And as you know, these ordinances have nothing to do with what happens in local school jurisdictions. All of that is covered by your local school board as well as by federal law. The Supreme Court has ruled repeatedly that transgender people are covered under federal laws affecting gender and sex. So again, companies are configured. And then people want to talk about bathrooms as if transgender people are going to start using bathrooms for the first time after you pass an ordinance. People are using the restroom with transgender people today. There are state laws that would go into effect for anyone that would violate anyone's privacy or any inappropriate behavior in a bathroom. And so all I want to say about this is to tell you that if you have questions about that issue, please ask me or someone who can help you through that. But the nastiness of that conversation, frankly, to me, is exactly why these ordinances are needed. And it's not about that, but there are people making it about that. And it is really sad to see. But I have seen other jurisdictions where, it has really been a beautiful thing to see people of all kinds of persuasions, demographics come together and say, yeah, this is right for our city. And I will tell you, like, if you can go back and watch the hearings that happened in Smyrna, a conservative city in the metro area that started out not being terribly interested in this and ended up with just some of the most incredibly heartwarming coming together of people in a community that I frankly have seen in a long time.
Thank you. Mr. Porter?
Thank you, Madam Chair. Ms. Wooler, thanks for joining us. I have a question regarding the implementation of the ordinance during the process of attaining business license. Have you seen from any of the other 13 cities that has implemented this ordinance that may have added attaining or understanding the ordinance as a requirement for attaining business license?
Yeah, and I'm gonna ask your forgiveness if I am incorrect, but I think maybe Clarkston and Decatur, and again, forgive me, I could just be like making that up, but I think both of those require that the ordinance be given to people when they apply for their business license, as there are other things, right? You know, when you go get a business license, you should be getting whatever your city requires of somebody who has a business license. It just kind of is part of that packet, just so that people are aware of it.
Thank you much.
We don't do that in Atlanta. I'm pretty sure not, because I get a business license every year and it's been some time since I've seen it.
Thank you. Anyone else on the subcommittee have any questions, comments? Okay, well, thank you so much, Councilwoman Woodard, for being with us today. You have given us some information that we needed, and believe me, you'll be called back again to help us and guide us through this process. So thank you for taking time out of short notice for coming on, but we really appreciate you being here today.
Thank you so much for having me. And I put my email address in the chat. Feel free to reach out to me individually if you have any questions. I'll add my phone number and then I'll jump off so you can continue your meeting without me.
Thank you. Well, you know, I always say we'll have our meeting. So we're asking again, do anyone have any questions, comments, or anything that you would like to say at this time? Commissioner Hassan, you have your hand up again.
I do. And Commissioner, thank you, Madam Chair. You know, I'm asking of the, I'm gonna say panelists, Madam Chair, if you don't mind, to help me with this question, because this is what sticks in my mind. I can't get past it, so I need a exodus right about now. If I'm an employee somewhere and I feel like I've been violated, I come to the city agrees with me, and they say the highest I get is $500. But if I take it to the federal level, I could possibly be awarded $10,000. So my question is, so would the city, when a person come in, would we recommend that person take it to the federal level, or we try to resolve it? Because the $500 not even going to the person, it's going back, as she said, it's going to the city. So the person in essence walks away with nothing, and they've been the one violated. So if I misunderstood it, somebody please help me.
Maybe we can, Commissioner Scott, maybe we can get Ms. Poole and Ms. Johnson to weigh in on that. That's, I mean, of course, at your discretion.
Yeah, and I was going to ask General Counsel Brown if he would he like to make a comment on that, or if that's something that we need to look at. I'm gonna ask Counsel Wayne Brown to comment, and then Ms. Johnson, if you have a comment, or anybody else on the panel.
Well, good afternoon, everyone. Madam Chair, Commissioner Hassan, to address your question. Augusta has not yet adopted an ordinance, but if you're referring to the draft that we have, the scheme that's in that draft does treat the money as payment of a code violation. In those cases, the money goes to the government, not to the complainant. So I believe that if I heard you correctly, I believe your impression of where the money goes is correct. It will not go to the person who allegedly has been suffered of a discriminatory act. It's treated more like a code violation.
Exactly. I get that. Yeah. And that's what
The ultimate punishment would be a withdrawal or a denial of a business license.
and that's the third or fourth time I'll listen. Excuse me. Can I respond, Madam Chair?
That's if you have 2 violations within a year, within a 12 months period, you are subject to that.
Yeah.
But again, everything is up for restructuring or renegotiation. This ordinance is not, the details of this ordinance and the pattern of this ordinance was not specifically requested by the commission. The commission wanted to see what a possible non-discrimination ordinance looked like. So this is what was prepared. It's not necessarily a suggestion by the law department or a recommendation by the law department. You needed something to get the discussion to start.
Madam Chair, can I respond?
Yes, last response.
Yes, ma'am. And so for the panel, once again, I'm fully supportive of us doing an NDO. I'm fully supportive of that. I just don't want us to see that we abuse persons and trying to protect their rights. We hinder them from maximizing the potential to get the full benefit of it. I mean, if I'm a big business person and I violate someone's right, $500 is a drop in the bucket. That's not even going to that person whose rights I have violated. And so just be mindful of that. There are probably many ways to look at this, or maybe I'm just being cynical, but trust me, I do want an NDO. I do want one. And so I don't want you to think I don't. I'm just trying to make it where it works for the persons who have the potential and been possibly violated. Thank you very much, Madam Chair. And I'm through at your discretion today.
Thank you. Ms. Johnson, did you want to respond, or do you have anything that you would like to add?
I'm kind of sort of in agreement with Commissioner Hassan, and the way my understanding of it was that the $500 would go to the city, but the rationale with the person would be that the company would either admit or deny that this person has been discriminated against. And if they have been discriminated against, then they would show us where they have put something in place to keep this from happening again.
Okay. Thank you. Ms. Parcell, you come back on the screen. Did you have your hand up, or you just came back on the screen? Okay, good.
I'm good. Thank you.
Okay. Well, I think this, again, has been great discussion, and we got some work to do. And we can't let it just lie down. We need to move forward, but we got to have good information. We have to have a good policy or NDO for our city. And my goal is for this to be friendly to everyone. We don't want to just say we're going to throw big business or small business or the person who really feel like they have been discriminated against. So thank you for the conversation. In 2 weeks, we will have another city that has a policy in place, and we will send the information out to you before 2 days in advance. Before we close out, let me thank Ms. Bonner, Mr. Donna, Zena McCain, Heyman for helping me out with this. And of course, always our IT program, our IT department, and all my colleagues for supporting me with this effort. So if all minds clear, we can close out, and we'll see you in 2 weeks. Thank you so kindly.
Thank you.
Thank you, Madam Chair.
Thank you.
Thank you.
All right, you all take care.
Thank you. Good afternoon.
No more conversation from